Hello and welcome to Defence Line, our weekly show on defence, security and more. Earlier this month, the High Courts in Delhi and Chandigarh passed two separate judgments which could be described as landmark judicial verdicts. In one, the Punjab and Haryana High Court directed that in order to ensure its independence, the Armed Forces Tribunal should be brought under the effective control of the Union Ministry of Law and Justice from the Ministry of Defence. In another order, the Delhi High Court quashed two promotions of a Lieutenant General, effectively reverting him to the rank of a brigadier. What do these two verdicts mean to the defence establishment? Is there a need to bring about further reforms in the military justice system in our country? This is what we discuss in Defence Line today with Rajiv Anand, an advocate specializing in military affairs, Major Navdeep Singh, also an advocate and an author on military law books, and Colonel S.K. Agarwal, a former JAG branch officer who is practicing in the High Courts. Gentlemen, welcome to the discussion. But before that, let us look at this report.
When the government announced the creation of the Armed Forces Tribunal a few years ago, it was widely welcomed as it was felt that it would speed up military justice. However, hopes of many military personnel seeking justice were belied due to the very structure of AFT, which many felt was flawed. This became apparent when the Delhi High Court recently quashed two promotions of a serving Lieutenant General of Army, relegating him to the effective rank of a brigadier. The High Court also made some very harsh observations on the military promotion and selection system and also the failure of the AFT to undo the wrong. What is more, this judgment came on the heels of another judgment of the Punjab and Haryana High Court, which ruled that the Armed Forces Tribunal be brought under the Union Ministry of Law and Justice, taking it out of the purview of the Ministry of Defence to ensure independence in its functioning. The court directions came on a petition filed by former president of the AFT Bar Association in Chandigarh, which pleaded that since the Defence Ministry had been made the parent administrative ministry of the AFT, it was wielding all-pervasive control over the tribunal and was also the rule-making and appointment authority not only for the staff but also of the judicial and administrative members of the tribunal. In its ruling, thus the High Court said the administration of justice is a subject matter of the Department of Justice under the Ministry of Law and Justice as per the Constitution's allocation of business. The bench of Chief Justice A.K. Sikri and Justice Rakesh Kumar Jain further said that in India, unfortunately tribunals have not achieved full independence. Incidentally, while passing its judgment, the Delhi High Court quoted Thomas Jefferson to say, "Experience has shown that even under the best forms of government, those entrusted with power have in time and by slow operations perverted it into tyranny. Tyranny points towards arbitrariness. The instant case raises it with full force." It is hoped that these two judgments and the observations of the honourable judges would set the trend for more reforms in the military justice system to be in tune with the changing times.
We are in conversation with three eminent military law experts. Major Navdeep, I'll start with you. The Punjab and Haryana High Court, in its decision on the AFT being under the Ministry of Law and Justice and not the Ministry of Defence, I think this was on your petition.
That's right.
What made you move the Punjab and Haryana High Court on this?
The basic system seems to be flawed. The Ministry of Defence is the first respondent in all cases. Every single case before the Armed Forces Tribunal is filed against the Ministry of Defence, and the same Ministry of Defence looks after the infrastructure, the appointments, the rule making, everything of the AFT. So a ministry which is under control, which is controlling the AFT, also happens to be the first respondent in each and every case, and this is totally in teeth of what the Honourable Supreme Court has held in many cases, that the control of tribunals cannot be under any parent ministry, under any ministry against which the orders have to be passed.
So what happens now? Surely the Ministry of Defence can move the Supreme Court?
Of course, the Ministry of Defence has every right to move the Honourable Supreme Court, but the Law Ministry itself is in favour of bringing tribunals under the Ministry of Law, and the Honourable Supreme Court has also decided in similar fashion in Union of India versus R. Gandhi and L. Chandra Kumar's case. So if the Ministry of Defence wants to go to the Honourable Supreme Court, it's welcome to do so. It has a right to constitutional remedy, but that is the law laid down by the Supreme Court. So
you don't expect they'll get much justice there?
Can't say, but they have a right. Let them move the Supreme Court if they want to.
Colonel Agarwal, what is your opinion? Should the AFT be under the Ministry of Law and Justice and not the Defence Ministry?
In the case of Colonel Bedi in 82, Supreme Court had decided that Army Act is taking care of Caesar to Caesar's wife. There should be a true judicial review. Now, present AFT is nothing but extension of the executive.
Okay.
They are selected by the MOD, appointed by them, transferred by them. How can we expect a Lieutenant General or even the judge of the sitting judge or the retired judge to quash the orders of the Defence Minister? He cannot. So, to have it independent, they should be directly under the Ministry.
But Colonel Agarwal, tell me, when the AFTs were set up, why were they placed under the Ministry of Defence?
I will explain. In 96, we had prepared the draft.
Okay.
I was the one who prepared it.
Okay.
It was not supposed to be under the MOD. It was to be under the Ministry of Law. That is why I myself discussed with Mr. George, Joint Law Secretary,
Okay.
about the composition and everything. But a mischievous role was played later on when Judge Advocate General wanted to become judicial member.
Okay.
And that is the time these things have gone wrong. Even if we go from the Baba Saheb Vikhe Patil Committee, Standing Committee on Defence Affairs, which had prepared this report
Okay.
on this, even they are not in agreement with that. They also say we are under the High Court.
So what report is this?
This is when this paper was prepared, it went to Parliament in the form of a bill
Okay.
in tooth and fill. Then the Parliament referred it to the Standing Committee of Defence, headed by Shri Bala Saheb Vikhe Patil. He was the chairman.
Okay.
And this is the report of that committee. This
But
entire
Colonel Agarwal, since most of the members of the AFT, except the judicial members, would still be military personnel, so how would the shift of supervisory control make a difference?
it will make plenty. First of all, if you permit me, I will take the background.
Okay.
Article 323 alpha was created in the Constitution to create CAT. Now, in that CAT Act also this provision was made, like Section 30 of the Armed Forces Tribunal Act, that appeal will be direct to the Supreme Court. Now, in 97 Supreme Court decided that you cannot have that. Article 226 and 227 of the Constitution can never be bypassed even by Parliament. And if you go through this committee report, I have flagged this, even in this it is specifically mentioned,
Okay.
226 and 227 will not be bypassed.
So Rajiv, are you also in agreement with Colonel Agarwal and Major Navdeep?
And definitely I am in agreement with them. See, when we challenge any issue before the Armed Forces Tribunal, the first party is Union of India, and that is through the Secretary, Ministry of Defence.
Okay.
Now here Ministry of Defence through its Secretary has been making the appointments of the administrative members who are holding the chair of justice. Justice imparting for the people, for the litigants who are going there. But the appointing authority being the first respondent, that always plays a role which needs to be curbed.
But by the same yardstick, Rajiv, should the High Courts not be under the Ministry of Law and Justice?
No, they are not. Here we talk of two things, the judicial superintendents and the administrative superintendents. These are the independent bodies. When the government is forming it, of the three functions by separation of power, the judiciary has to be independent. Like Colonel Agarwal referred to Pritipal Singh Bedi's judgment of 1982, the wording there, the Honorable Supreme Court said, the independent judicial body. Now that independence has to be secured. That's what has been done in L. Chandra Kumar's case for the tribunals, R. Gandhi's case. They say these are the judgments under Article 141 of the Constitution of India. When these are under Article 141, these are binding.
But how will things play out when the control of the AFT changes hands? How would the AFT members be chosen?
It will be from the scratch, the appointment. There, like in these judgments only, the honorable courts have referred to the Central Tribunal Division that is to be created under Ministry of Law and Justice. Now this will be an umbrella body for the country, entire country, of the various tribunals that will be either created or have already been created.
Okay.
Now there will be a proper code of conduct, the various qualifications, the other requirements which an administrative member also needs. I'll give you an example. Administrative member is holding a post where he is imparting justice under Section 15 of the Armed Forces Tribunal Act. He is even hearing the appeals. Now these appeals are akin to, and the powers are akin to, the criminal appeals before the criminal jurisprudence, even the high courts.
Okay.
Now here, Indian Evidence Act, the procedures laid therein, the procedure laid in the Criminal Procedure Code play a vital role. Now these administrative members, with all respect to the selection committees and these members also, in fact have very little knowledge about these technicalities of these acts.
So, that brings me to the other point. There is even a feeling that all judicial members, all members of the AFT, not just the judicial members, should actually have some kind of a judicial background, because the military officers who are there have no military knowledge.
That should be a parameter. That should be a parameter to say when the selection is being made, due importance should be given to any journal, because they are at the very superior ranks.
Okay.
They must have held lot of court martials. They must have been presiding officers of lot of court martials. They must have in some way assisted. If we get
But Rajiv, there is a provision for study leave within the army and within the defense services. Why can't they actually pick up those officers who during study leave have perhaps studied law?
Yes, that is one, if they already have that. If they don't have that, actually there should be a capsule 6 months to 8 months before they come here. They should have a capsule. It can be on job or before that, pre-induction sort of, where they should be given technicalities, principles of law which are governing these important statutes.
And I would like to add something.
Yes,
and it should be totally emphasized that they are not sitting there to defend the government. They are not sitting there as the extension of the state. They are sitting there in a judicial capacity. They are not there to defend the actions of the government.
But what about the issue of the personal biases coming in? As of now, a lot of AFT members, military members, may have served with those who are appearing before them, or may have actually heard about the spoken reputation of some of them.
That's okay if a person deals with an issue dispassionately and a person is clean enough. I don't think that should pose any problem. And of course a person can recuse himself. A member can recuse himself if he feels that he is unduly biased or prejudiced on an issue or against a person or in favor of a person.
That doesn't happen very often.
That's very unfortunate.
You know of that case in before the Chandigarh AFT, where one of the officers actually alleged that a member was friendly to somebody else.
It is a very important issue.
Yes.
First of all, there is a provision that Army, Navy, Air Force, their officers are to be appointed. Now, we are having AFT. I have not seen any Air Force or Navy officer.
Why is that?
We are having 3 benches here. In my opinion, there should be 1 Army officer, 1 Navy officer, 1 Air Force officer. Cases of the Army should not be heard by the Army officer bench. Case of the Navy should not be heard by the Navy officer.
But when the initial, the Act and the rules were framed, why was this condition not put in?
You see, everything can't be in writing. Something is expected from the chairman also.
Okay.
Everything can't be in writing.
Right. I'll just come back to you. Here we'll take a short break. When we return, we will continue the discussion on the High Court decisions affecting the armed forces. Welcome back. We are discussing the need to improve the military justice system. Rajiv, the other case in which the Delhi High Court has quashed 2 promotions of a Lieutenant General is very curious. It is unbelievable that this kind of a thing would have happened, and it appears that even the AFT had failed to give any kind of justice.
No, here the selections have been quashed. Not only that, the observations are very vital. The observations which the Honorable High Court of Delhi has given is that in the case in hand before the Honorable High Court, they have found apparent the manipulation of the policies, how these have been manipulated to favor some and to disfavor others at that level where the selections are being made. Thereafter they have categorically said that undue haste is being shown by the authorities who are in power to favor, and that has come apparent before the records when these were being scrutinized by the Honorable High Court. Thereafter,
but what about the in-house system within the army? How could this not be kind of picked up and
No, I am coming to that. In-house now, after these observations, is required to be rectified and corrected. Now, the problem is with in-house only. These things have been observed, what activity has taken place in-house. Now, when this activity has come on the judicial records in a judgment that has been given by them, quashing these things, now they say even misleading statements were made before the court.
So now, that means indirect strictures have been passed against the MS and the AG of the army?
Definitely these have been done, and once these have been done, now let's not bring it to all of us, but internally they should rectify it for days to come. In future this should not happen. There has to be policies. The authorities who are implementing these policies should observe. For future, the checks and balances have to be there so that such things does not happen.
Absolutely. Colonel Agarwal, what happens now? Does this Lieutenant General become a brigadier?
No, firstly I will answer the first question little bit.
Yeah.
The system itself is faulty. You will be surprised. 1,000 officers are considered for promotion to full colonel and time spent is 1.5 minutes per officer. 20 years career is scrutinized in 1 minute. What actually happens, you said in-house. Actual promotion board is held about 3 months before by the MS branch, and they decide whom to promote, whom not to promote, and then marginal cases.
Okay.
And the board only consider the marginal cases.
So it's just a formality that happens.
It is
before the
only
board.
a formality. अगर आपने किसी को प्रमोट कराना है तो उसके पॉजिटिव पॉइंट बताओ, नहीं कराना नेगेटिव बताओ. Now we come to the judgment part. The person who has been already promoted, now he has got the option. He can put up his papers
and go
home as a Lieutenant General.
Okay.
Because he has performed the
He
duties
may not
rightly
be,
or wrongly.
he may not be having the substantive rank of a Lieutenant General yet.
No, in the army, all of them, all higher appointment holders
Okay.
are now substantive.
Okay.
So you cannot bring him down under any law. So he has the option.
But suppose he decides to serve in the army and complete his service tenure.
So he will not be able to do it with the stigma. Then tomorrow they may be at the court of inquiry and he may be court-martialed, something wrong there.
Right. Now, Colonel Agarwal, the High Court has made some very harsh observations. It said such appointments would breed indiscipline and insubordination and create a sense that it is currying favor with superiors and not merit which earns promotions. Now, surely this is a very big reflection on the entire military defense establishment, which means the army and the MOD.
MS branch is full of skeletons. There is not a single promotion board. As a OIC legal cell, since 83, I have got plenty of experience. No promotion board is foolproof. Favors are there. Promotions are there. Postings are also favored. अगर आपने किसी को सुपरसीड करवाना है एज आर्मी कमांडर तो उसको पहले लेफ्टिनेंट जनरल को स्टाफ पे भेज दो. उसको लेफ्टिनेंट जनरल की कमांड रिपोर्ट नहीं मिलेगी. दूसरे को कमांड पे भेज दो, उसको रिपोर्ट मिल जाएगी, स्टाफ की भी मिल जाएगी, वो आर्मी कमांडर बन जाएगा.
But Rajiv, since this kind of manipulation has now come to the fore, don't you think all those who are responsible for manipulating the system should be hauled up?
Yes, definitely. We have a case in hand wherein things have become apparent. The officers concerned who could not make it to the board have been projecting that such things were happening. Now in this case it has come, the observations are being made. At least a start should be made at this place from these observations for those who are responsible, so that further policies and the guidelines should be strengthened on these parts so that in future such things don't happen.
Right.
No, I will just
Yes.
answer one query on this. Whom will you hang? There is a chief of army staff is there.
No, there could be a court of inquiry to establish the people responsible.
I am giving to that. Chief of army staff is there. 6 army commanders are there. 7th vice chief is there. Now this is the committee which selects them. Whom will you hang?
No, but as you said, the MS branch is the one which prepares the dossier, so the MS branch should be taken.
Whosoever, but because in-house board is held by the MS. Now MS should be hanged because there is a secretary of the selection board. Secretary should be hanged. Why did you do wrong briefing to the selection?
Major Nadeep, since the petition before the Punjab and Haryana High Court was yours, now what are the other reforms that you have suggested?
The first reform is that giving teeth to the tribunal. There are no contempt powers with the tribunal. Imagine a person, there are existing cases, a person is acquitted by the AFT from a criminal case and they don't implement the order, or a person is released on bail and they say we will not release him from military imprisonment.
Right.
Where does the man go? There is no power of contempt, and shockingly when the initial Colonel Agarwal had stated, when the initial thing was drafted, there were powers of contempt. There are mentions of powers of civil contempt in the rules. They are mentioned in the forms, but there is no substantive provision.
But before we go further, let me get Colonel Agarwal into the discussion. Colonel Agarwal, the AFTs have no power of contempt. Is that hindering their functioning?
It is. Because you cannot have a court or authority who cannot ensure the compliance of its orders.
So which is the authority which actually does the compliance?
I am of the personal opinion, although the chairman had made a statement the other day here only in Chandimadar, I should have contempt powers. I want to ask a question, who says you don't have the contempt powers? But then the question comes, he will be charging whom? Defense Secretary? Who is appointing him? Okay. We come back to the same question.
Okay.
Caesar to Caesar's wife. It is in my opinion, the present AFT is extension of the Ministry of Defence. That is why it must be ruled from the MOD command and control.
So that is why the Punjab and Haryana High Court is very important.
And interestingly,
yes,
this matter was referred to the Standing Committee for Defence, and the Defence Services have opposed this. They said that no, contempt powers should not be given to the AFT. That's how. Why? I mean, the teeth are going to, these teeth are going to bite the defense service, and you're asking them whether contempt powers should be there or not, and why should they oppose it?
I go a step further.
I
go a step further. Why should a chairman say I should have the powers of contempt? Let him charge for contempt. Let defense secretary and chief say you don't have the power.
There is need for the AFTs to be proactive.
AFT to be proactive.
Yeah. Now, Majid Navdeep, the two other issues you have raised before the Punjab and High Court was, one was that the vacancies of the judicial members should be filled up, and secondly, you had said that the selection committee, this committee which selects the members of the AFT, that should be reconstituted. I think it has two serving bureaucrats.
It has two career bureaucrats, the law secretary and the defense secretary, and they're sitting over appointments of serving or retired high court judges.
Okay.
Number one, bureaucrats should not be allowed to comment on the capability of judges, and number two, they are junior in the warrant of precedence and the official pecking order. That is one objection. The second thing is that even when appointments are being made, they must ensure that appointments are made, especially of the administrative members, on the basis of their approach while in service. They should be balanced people. They should not be extreme in their views, because after all, you're dealing with sensitive issues such as disability pension also.
Right.
Sensitivity to human life should be there, war widows, disabled people, disabled personnel. So the selection also has to be from amongst balanced people who do not feel that they are an extension of the state or that they are there to defend the policy. They should have interpretational skills. It is not that they should only ratify what the government is saying. Unfortunately, we have seen this problem creeping in, but of course with a certain capsule, as Mr. Rajiv Anand pointed out, with a certain capsule and with a certain amount of acclimatization, this can be worked out.
Rajiv, what else should be done to make the military justice system more responsive?
To start with, training. Military justice system does not only include the administrative side or aspect of the matter, it also includes the criminal justice. The commanding officer, to start with, is empowered with various powers and functions, wherein he will look into the offences being done by the men under him. He will punish them with imprisonment also, rigorous imprisonment also. Okay. Now here the training part is lacking. From there the issue starts. Then it goes to the higher headquarters, where we find members, the higher superior authorities are also lacking training in such judicial aspect of the matter to deal with it. Here in 1982, in Pritipal Singh Bedi's only, they said retributive justice should not take place. Now here that is what exactly is happening. It's been, we are into a civilized society, but still carrying on the retributive justice. You have done this wrong, this is the punishment. Now the circumstances prevailing, the extenuating circumstances, which why judicial training will only come to you, are totally being ignored.
So in your opinion, judicial training is of paramount importance?
Definitely. When they are exercising judicial power, including criminal justice, they must have some training in that.
Right. Colonel Agarwal, since a lot of the problems actually stem from the promotion of the officers, so what should be done to make the promotion boards more transparent and fair?
You have to stop the inside holding of the board. Seeing the number of the people, you should extend the period. Don't say within 5 days you have to complete it.
Okay.
Let them place the complete board. There should be no secretary, no MS branch officer should be involved in the selection process. And they should be fair. Composition should be okay. Now what is happening? Many of the officers have served with the board members.
But maybe, even if you give, say that take 15 minutes to look at one officer's dossier, I think it may not be a very fair system, because you need some kind of expertise to even, study various documents and the service records.
No, on that what happened, we have got a procedure. In one sheet you call it MDS.
Okay.
Everything is on one page.
Okay.
Now, I will give you an example. If there is an abrasion in my dossier and it becomes inoperative, it is supposed to be removed totality.
Okay.
But what happens? They put a paper on that. So and so record which was given to him severe displeasure on so and so date for so and so has become inoperative with effect on so and so date.
Okay.
So this paper is pasted on that. The effect
so even that could influence the members.
It influences.
Right. Since you're running out of time, Major Navdeep, court martials is another problem area. Is there any kind of reforms that you have in mind as far as the court martials are concerned?
The inherent system, the existing system is not draconian. It's perfectly fine. There are checks and balances.
Okay.
If those checks and balances are exercised properly, I don't think there's any major problem or a major hassle. But as they say, it's the person behind the machine that matters and not the machine itself. So I would say that checks and balances are fine.
But as Rajiv said, a lot of those people who are there on the court martials, you know,
are not judicially trained.
Are not judicially trained.
That's even the principal bench of the AFT has pointed this out. And of course, with all these things, smoothly these things can be sorted out. These can be resolved. It's not a major stumbling block.
Rajiv, before we close, a quick comment. Should the summary court martials continue?
No. That's the precise answer. These should not be. In the name of summary court martial, the commanding officer has whims and fancies sitting on his shoulders.
But most army officers feel that if you do away with the summary court martial, the discipline within the force would suffer.
No, summary court martial was a field time concept.
Okay.
It was never a peacetime concept. Now, under the garb of that authority that's been given to you to conduct summary court martial, the whims and fancies of the commanding officers.
So are you suggesting that let's do away with the summary court martial in peace times? During war, it can be there?
No, it must be justified. There should be some reasoning. We can't say under the discipline of the army, the entire reasoning and justification should go. It has to be there. Yes, if some sound reasoning and justification is the basis of summary court martial, even
it comes to the same thing. It is the person behind the decision.
Yes, definitely. That's the person.
Right. Thank you very much for joining us in the discussion. Though the decision of the government to set up the armed forces tribunals was a welcome step, the recent court decisions further underline the need to bring about more reforms in the military justice system. That is all in Defence Line today. Do write your feedback. Good luck and goodbye.